Kayla's on. Okay, I got you. Don't. We're swerving. Skirt, skirt. We're listening live.
Hopefully, when they start speaking, hopefully you can hear it. I think I unmuted it.
All right. We are on the record in court file 34 CR 24 342. It's the state of Minnesota versus Kayla Christine Rekieta. You are Ms. Rekieta?
Yes.
All right. We've had some trouble hearing everyone this morning, so if you could get a little closer to the microphone and speak a little louder. Your appearance today is based on a complaint order for detention with 3 counts. I have your date of birth is March 9.
Yes, sir.
All right. The record should also reflect that Alex Kornahachi appears for the state of Minnesota. Ms. Rekieta, your current address.
Is that my internet
Yes,
or?
Okay.
And you also get your mail there?
No, sir. We have a PO box.
All right. What is the PO box to ensure that you get your mail?
PO box 97.
And
Sorry.
Mr. Rekieta lives there as well.
He's muting
He's
it
also a
himself.
co-defendant with you.
Yes, sir.
And he would get his mail there as well.
Yes, sir.
Count 1 is second-degree possession of 25 grams or more of cocaine or methamphetamine. This has been charged out as a felony, so the maximum sentence is 25 years in prison and/or a $500,000 fine. Offense date was May 23rd, 2024. Count 2 is possession of ammunition or a firearm by a user of a controlled substance in violation of Minnesota Statute 624.713 at subdivision 1. This is a gross misdemeanor, so the maximum sentence is 364 days and/or a $3,000 fine. And then lastly, count 3, neglect or endangerment of a child. Again,
Jim
a gross
made fun of
misdemeanor.
him when he says,
Maximum
and by the way, this is probably the
364
single
days,
most base take that
and/or a
Dear Medicare has ever made.
$3,000
He says,
fine.
heterosexual Christian
First
man
question
watches
is,
one
you understand what you've
episode
been
of
charged
anime.
with?
I understand, yes.
All right. And the maximum penalties associated with each offense or each count.
Yes, sir.
All right. When someone has been accused of an offense such as this, it's important that you understand your rights. Starting point is that you are presumed to be not guilty. You don't have to prove your innocence. Rather, the state has to prove your guilt, and they have to do so with evidence beyond a reasonable doubt. 2, you're entitled to counsel, legal counsel, and if you can't afford it and an attorney, the court would appoint one for you. 3, you're entitled to trial by jury if you so choose. If there's a trial, all members of the jury would have to agree that the state had met its burden of proof beyond a reasonable doubt before you could be convicted. If there's a trial, you could give your side of the story if you wish, but you don't have to because you have a right to remain silent. Indeed, you don't have to prove anything, so you don't have to say anything. If you remain silent and don't testify, the judge and the prosecutor cannot make comments about that because it is your constitutional right, nor can the jury consider it. You have a right to confront, challenge, or cross-examine any witness who testifies against your interest. You have a right to call witnesses and the power of subpoena to force witnesses to come and testify on your behalf. You have a right to receive all of the state's evidence and information, including exculpatory information, before trial. And at the end of the day, if you think the judge or the jury made some mistakes, you have the right of appeal. Do you have any questions about those rights this morning?
No, I do not.
You have a right also to have me read the complaint to you. If you read it or you're able to read it, you can waive that right. Do you need for me to read it to you?
Not at this time, no.
Very well. Any objection to setting these hearings tracking your husband's case? Or would you want a separate hearing?
I think I would like this tracking his.
Very well. We will set those and track at the same time. You can change your mind if you'd like. This is sometimes called a bail hearing, and then you would come back for an arraignment. We combine those hearings for Mr. Rekieta. Do you want to do the same thing and then just set this for a contested omnibus? That's a yes?
Yes, please.
You're nodding, but you're yes?
Yes.
Okay. Mr. Cornahachi, does the state have any release conditions?
Yes, sir. Yes, Your Honor. We would
Go ahead.
ask for the same conditions as Nicholas Rekieta, $50,000 unconditional, and the alternative RPR with standard conditions. If the court would like, I can repeat the conditions I had asked for.
You're going to have to. I threw it away. So
No problem. So that would be no use of controlled substances or alcohol, random testing, no use or possession of firearms, contact probation as directed, don't leave the state without permission, remain law-abiding, and other standard conditions.
Ms. Rekieta, any objection?
No.
Very well. Court will order unconditionally amount of $50,000 cash or bond. Conditionally, you'll be released on your own personal recognizance. But in all instances, you have to remain law-abiding and show up for your court appearances, and we'll give you that date shortly. It'll also be noted on this release order. You are to abstain from the use of alcohol or any mood-altering chemicals not prescribed by your physician. That will be subject to random testing, so I'll have you report to probation, sign their agreement, and cooperate fully, which means keeping in contact with the pretrial probation agent. You are not to possess any firearms, ammunition, or dangerous weapons, and don't leave the state of Minnesota without prior approval of the court. Any questions about any of that?
No, sir. Understood.
Madam Clerk?
Your Honor, that is August 20th at 2:45.
All right. And that's all from the Candy. All right. Is that all from the Candiac County Jail?
That's all we have, Your Honor.
Okay. Thank you.
Thank you.
Candiac County Jail signing off.
Very simple. Very straightforward.
Okay. So that is it.
That's what I just said. Get off my screen. Don't know who you people are. I received a message from an attorney, and he indicated to me that the fact he has chosen to represent his wife as co-defendant is a much bigger deal than I initially suspected. I suspected that there would be a conflict of interest, but he says he should be disbarred for trying to represent a co-defendant. Forget the rest of the shit he's done. That's actually per se conflict and per se against the ethical rules. It's unconstitutional everywhere because it is a fundamental issue with part of a zealous representation of your client. Part of a zealous representation is the freedom to throw the client's co-defendant under the bus. It says it's a blatant problem. Even if he was not also charged, he can't represent co-defendants because they need to be able to throw each other under the bus, whether or not they choose to do so. They need that ability. So if Rekieta is permitted to represent her, it's going to be up to the prosecutor to allow this, though. It may be a thing where they have to get different lawyers down the road, and he's allowed to represent her for the bond hearing. But when it comes to the actual trial, the issue that the state has is that if she's allowed to accept her husband's representation in court and then is convicted, like let's say they get the maximum of 25 years each, right? She can then appeal this and say, I was not given a zealous defense by my attorney because he was my co-defendant. And that's an extremely strong argument for a retrial due to inadequate counsel. And in that case, it would actually be the state's fault because they should be saying, no, you can't do that. So it might be a thing where the state, the guy that is the prosecuting attorney sounds very young. You can, like, his voice is like squeaky. It's so squeaky that if he was playing Team Fortress 2, people would be telling him to shut up and stop using his mic. So he's very young. So I don't know if it's like a lack of experience or if he's just permitting it for the bond hearing stuff, but there's definitely a serious conflict of interest in that. As far as the release of their conditions, I think both of them had $50,000 or strict supervision, and I think that they will have a no contact order with April as a co-defendant. I guess they get to keep their kids. Actually, there was the way that they phrased it with Rekieta was that they were asking for contact limitations, but they didn't explicitly say what contact limitations. So I don't know if that means there will be. He's going to have to choose, basically. Like, they might sit them down and say that your charges are so severe, we cannot permit you to have sole custody of your own children until your trial. So I think that it was either $50,000 or supervised. So they might have to pay $100,000 in bond in order to not be supervised on release, because if they violate the conditions of their bond, they lose that money. Yeah, I think you lose. I think the way that bond works, and it's a complicated, but it's like you pay. What you do is you go to a bondman, and you give him as collateral like your house, and then you say, "I need $100,000 to post bond." I think the court takes 10% of that as like a fee, so that $10,000 is just gone. And then you get like the rest of it back if you obey all their rules up until the trial. I'm pretty sure that's how that works. I'm not 100%, but I think that's the gist of it. That's how it works. So if you don't show up, the guy takes your house and he sells it, and then you get the rest of the money back as collateral, I guess. But yeah, it's not either or. It's not either or. I thought it was $50,000. Let me ask. I thought it was $50,000 or supervision. Because the way that it sounded to me was that he had the choice of doing $50,000 bond or bond on recognizance and then also supervision. It said or. Or I am correct. Yeah. When my chat tries to tell me things as if I don't know things, chat, come on now. Come on. You should learn to trust me by now. I'm not completely full of shit all the time. He can get out without paying anything, but if he chooses to do that, the conditions of his bond will be stricter. They will monitor him. They will drug test him. If he pays the cash, then they have the cash as collateral instead, and they won't supervise him. So if they make the conditions that you can't supervise your kids, I'm pretty sure that means he either has to pay $100,000 in bond, or he has to eat shit on that and have a supervised visitation or something. It can be that cruel. So he's not in a good spot. if that hasn't been made clear by now, he's not in an enviable position.